Hey, good morning, everyone. Back again for our third and final mini edition of estate planning. Then I promise we'll get to some lighter subjects moving forward. I know people are probably tired of hearing me talk about this, but I wanted to quickly go over, dying without a will and power of attorney. So the reason to have a will is if you pass away without a will, you're considered passing away intestate. And with this, the court is going to decide where money's going to go, how your estate's going to be determined, and all of your family members or anyone who cares to can challenge this. Now, I'm big into stories personally, so I'll share a story with you. This is a client of ours. She had, I believe it was her aunt passed away, and the entire goal of her aunt is it wasn't a major estate. It might have been roughly $300,000. But she wanted to give this money to the Big Oak Ranch. She chose to go a cheaper route, and she tried to do this herself, meaning she pulled documents from the internet, and she thought in her mind that she had her will taken care of. Well, it turns out she did not have the required number of witnesses, so her will was invalidated, and they had to start this entire process. Now, our client, she is an incredibly sweet lady. She spent almost 2 years tracking down all these distant relatives. And keep in mind, we're here in Alabama, she's Southern. She's having to call people out in California. And you can imagine how that went. Hey, I've got some money for you from a relative you never heard before. Click, hang up. But after the end of the day, and she spent all this time doing this, the Big Oak Ranch ended up getting something like $30,000. So very important to have a will and to go to a lawyer, go to an attorney, and get this done correctly. Talking about power of attorney document. Another very important and considered an essential part of doing your estate planning correctly. The reason a power of attorney document is so critically important, especially with what we see on a regular basis, is let's take your qualified accounts, your retirement accounts, for example. So if you have an IRA, IRA stands for individual retirement account. So even if you're married, and we'll use a case study that has unfortunately happened. So let's say that you're married. I'll use my wife and I. We're married, my wife is my beneficiary on everything. Should I die, something goes to her, or everything goes to her. But in this example, we had a gentleman who didn't pass away, but he had a stroke. So he's still alive, and they needed money to start his care. He was needing round-the-clock care. And they did not have a power of attorney document on file. Now, yes, you can go back and get this. It's not the end of the world. But for that time period, and if his wife were to reach out to us, and when she did, we had to tell her that we cannot legally process any transaction. It is not her account. Even if you're married, if that's your beneficiary, if that's where the money's supposed to be going, for a retirement account, it does belong to the individual. So without this document, naming someone that can act on your behalf in a state of incapacity, you are in a tough situation. Thanks for joining me on this mini-series. I tried to cram a lot of material into a short time period. Again, we typically spend north of 2 hours going through this portion in our classes. But I hope it was a little bit valuable, and please do go see an attorney. We have some great relationships here. Be happy to let them know that you're on your way, because I do think it's very, very important, and most people overlook this. Take care.